Hello everyone, it's me, Leonard French, your favorite copyright attorney. There is an update in the copyright/computer fraud lawsuit that JW Motion filed against JW Batteries. JW Batteries has won their motion to dismiss, and Judge Edward Chen of the United States District Court for the Northern District of California has entered judgment in favor of JW Batteries. Unfortunately, it's probably not the end of the legal dispute between Onewheel maker Future Motion and replacement battery maker JW Batteries. Let's talk about the decision and why this might be just the beginning. If you recall from my previous video, Future Motion sued JW Batteries over JW's JW-FFM chip that allows JW's replacement batteries to talk to the Onewheel's board control unit. Some later versions of the Onewheel XR firmware prevent the board control unit from accepting a replacement battery. The JW-FFM chip is meant to allow replacement batteries to bypass that lockout. In its lawsuit, Future Motion had claimed that copyright's anti-circumvention provisions, which are meant to protect against bypassing technological protection measures which control access to a copyrighted work, that those measures also prevent JW Batteries from selling its JW-FFM chip, since the chip likely has to trick the board control unit into thinking an authorized battery is present. Future Motion had also claimed that the bypassing done by the JW-FFM chip violated the CFAA, the Computer Fraud and Abuse Act, which makes a violation out of knowingly accessing a computer without authorization or exceeding authorized access. Since the JW-FFM chip accesses the Onewheel's board control unit without Future Motion's authorization, that's a violation of the CFAA, says Future Motion in their complaint. Last, Future Motion had claimed a violation of their trademark on the Onewheel XR logo. Apparently, JW Batteries made a JW XR sticker that uses the same style as Future Motion's XR logo on the Onewheel. I did a quick trademark search for Future Motion's trademarks and found that the 3 attempts Future Motion made to trademark the letters XR were all abandoned. Future Motion does not seem to own a trademark on XR. But all of that is moot, at least for now. JW Batteries challenged Future Motion's lawsuit in the Northern District of California on jurisdiction grounds. I'll give you the short version here, and you can stay tuned for a deeper dive into jurisdiction law after the summary. But basically, government entities only have power over certain types of legal matters in certain geographic areas. When you file a federal lawsuit, for example, you must include a statement explaining how the court has jurisdiction. For copyright matters, only the federal courts have subject matter jurisdiction. That is, only federal courts can hear copyright matters. So the Federal District Court for the Northern District of California was the correct court for subject matter jurisdiction over copyright and trademark and Computer Fraud and Abuse Act claims. But the court also has to be in the correct geographic location. The Northern District of California will only have jurisdiction over a particular geographic area on the west coast of Northern California, from south of San Jose up through Eureka. Importantly, JW Batteries is not located within the Northern District of California, so JW Batteries' motion to dismiss was based on a lack of the Northern District of California's jurisdiction over JW, which is located in Texas. In order to determine if a Texas company is under California's jurisdiction, there is an important legal inquiry that must be made, evaluating both the facts of JW Batteries' operations and interpreting those facts within the law of jurisdiction. Jurisdiction scholars will immediately recognize cases like International Shoe, Ashcroft v. Iqbal, and Bell Atlantic versus Twombly, along with phrases like minimum contacts and purposeful availment. The short version is that there is a threshold which can be crossed, which would bring an out-of-state company within the jurisdiction of the courts in another state. That standard is often phrased as whether that company has purposefully availed itself of the benefits and protections offered by that state, such that the out-of-state company could reasonably expect to be hauled or haled into court in that state. This gets more complicated, and this is the oversimplified version, but As applied to the JW Batteries case, the court in Future Motion's lawsuit had to evaluate whether JW Batteries did enough business with California to bring JW under the California court's jurisdiction. Judge Edward Chen ruled that JW Batteries does not have enough contacts with California that it could reasonably expect to be hauled or hailed into court in California. While this is certainly a win for JW Batteries, it might not be the end of the legal dispute. A dismissal on jurisdiction grounds eliminates the case in that jurisdiction, but it doesn't eliminate the underlying claims. Future Motion could file the same case in the correct jurisdiction, likely JW Batteries' home district in Texas, and pursue the same claims there. The whole lawsuit would start back up again, and this time there would be no jurisdiction defense. I believe that JW Batteries has good defenses on the merits of the copyright claim, the Computer Fraud Act claim, and the trademark claim. My reading of the copyright's anti-circumvention provisions says that the DMCA does not apply. My reading of the Computer Fraud and Abuse Act says that it's not a violation for you to authorize a chip to make your electric skateboard work with a third-party battery. My research into the XR trademark says that Future Motion doesn't have a trademark on those letters used in connection with sales of Onewheels. So I think that JW Batteries will win a lawsuit if Future Motion brings such a case in the appropriate district in Texas. But winning a lawsuit is not without consequences, even for the winning party. There are often costs, expenses, and fees that are not reimbursed even when you win. In copyright cases, those things are such costs as travel expenses and expert witnesses, and judges have discretion to pare down attorney's fees, meaning the prevailing party still might not get all of their attorney's fees awarded to them, even in a successful defense. I asked Jim Martin, the owner of JW Batteries, about the win in California. He asked me to point out that this doesn't mean the case is over, and that for us to fight jurisdiction, we had to spend $100,000. I guess I want people to understand that what FM did to us was really shitty. Jim says Future Motion has told his attorneys that they will refile in Texas. So that's the majority of the update with the dismissal of the Future Motion versus JW Batteries case. If you want to hear more about how the court evaluated jurisdiction of a Texas company in a California court, stay tuned. Otherwise, please leave a comment below telling us how you feel about Future Motion's lawsuit against JW Batteries. All right, on to the evaluation of jurisdiction. The court considered the following facts when determining whether JW has a presence in California for purposes of personal jurisdiction. The court noted that JW was a Texas corporation. Its only physical location is in Texas. It does not operate any location in California. The product at issue includes the chip, the JW FFM chip, as well as batteries. Specifically, the batteries will not work unless the JW FFM chip is installed and the chip does not function as planned without the battery. To develop the JW FFM chip, JW borrowed a Future Motion Onewheel from a Texas resident. It did not purchase the product from Future Motion or anyone else. JW sells all of its products, including the JW FFM chip, through its website, jwbatteries.com. JW does not have a contractual relationship with anyone in California for sales or distribution of its products. JW maintains that it does not run any advertisements for its products in California or otherwise. Future Motion suggests that JW still advertises through its website as well as through its Instagram and Facebook accounts. However, Future Motion has not pointed to anything specifically about JW's website or its social media accounts that indicates a targeting of California customers. JW has shipped its product to customers in 45 states plus DC and about 10 jurisdictions outside of the US. Since JW started tracking distribution of its stickers, it has sold 79 stickers nationwide, with 15 of the 79 being sold to people in California, about 19%. For a 16-month period from September of 2020 to January 2022, JW had 583 sales with California customers, including about 60 returns. The bulk of the sales, 570, involved relevant products, not just chips but also batteries. Therefore, on average, there were about 36 sales of relevant products per month to Californians. For a similar 17-month period, JW had 3,415 sales in total, most in the United States. The bulk of those sales, 3,350, involved relevant products. If there were 570 of 3,350 sales of relevant products to California, sales to California presented about 17% of the total. JW's sales to California also account for less than 19% of sales in terms of revenue, not just in units sold. JW can install the chip for its customers if requested. JW found 2 instances in which a customer sent it a product from California so that JW could install the JW FFM chip. JW also suggests how customers can get a JW FFM chip installed by someone else. For example, on its website, they have an FAQ section where it states that we highly encourage individuals to have the chip professionally installed, that Stoke Life Services can handle the installations, and that john@stokelife.guru can be contacted for more information and for the SLS shop in your area. SLS is a global personal electric vehicle repair shop network, something like an Angie's List for repair shops. Although JW makes referrals to SLS, there is no indication that JW has a contractual relationship with SLS. Counsel for JW confirmed this at the hearing. Future Motion has provided evidence demonstrating that JW has communicated with prospective customers located in California, as well as existing customers in California, to provide technical support. These communications, however, do not indicate that JW is reaching out to prospective or existing customers in California. Rather, the communications indicate that these customers are reaching out to JW. Nor is there any indication that the communications with customers generally were targeted at California. As to the law of personal jurisdiction applied to those facts, the court noted, there is no dispute here that JW is not a resident of California. A district court's exercise of jurisdiction over a non-resident defendant comports with due process when the defendant has at least minimum contacts with the forum, and subjecting the defendant to an action in that forum would not offend traditional notions of fair play and substantial justice. Future Motion argued for specific jurisdiction. Specific jurisdiction requires that 1. The non-resident defendant must purposefully direct his activities, or consummate some transaction with the forum or resident thereof, or perform some act by which he purposefully availed himself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of its laws. 2. The claim must be one which arises out of or relates to the defendant's forum-related activities. And 3. The exercise of jurisdiction must comport with fair play and substantial justice, i.e., it must be reasonable. The Ninth Circuit Court of Appeals, where the Northern District of California is located, applies the effects test that focuses on the forum in which the defendant's actions were felt, whether or not the actions themselves occurred within the forum. The effects test, which is based on the Supreme Court's decision in Calder v. Jones from 1984, requires that the defendant allegedly must have 1. Committed an intentional act, 2. Expressly aimed at the forum state, 3. Causing harm that the defendant knows is likely to be suffered in the forum state. JW focuses on the express aiming prong of the effects test. It argues that all it has done is sell products on the internet on a national scale, which is not enough to show express aiming at California, even taking into account the sales it has made to California. Future Motion disagrees. For the reasons discussed below, the court finds JW's argument persuasive. Although at this juncture, Future Motion need only establish a basic case of jurisdiction, it has not met even that relatively lenient standard. The court notes that Future Motion's analysis has a fundamental flaw, which JW pointed out. Several of Future Motion's arguments in favor of personal jurisdiction are dependent on JW's conduct expressly targeting Future Motion. That is, through the stickers and through the chip named FFM, which allegedly stands for F Future Motion, with Future Motion suffering injury in California since it is located there. But the case law on which Future Motion relies to support its argument largely predates the case of Walden versus Fiore, a 2014 Supreme Court case, which held that we must look to the defendant's own contacts with the forum and not to the defendant's knowledge of a plaintiff's connection with a forum. This leaves Future Motion with 2 arguments, specifically that there is personal jurisdiction over JW based on 1, its communications with California residents, and based on 2, its sales to California residents. FutureMotion has provided evidence that demonstrates that JW has communicated with both prospective and existing customers located in California, but nothing in these indications suggests that JW is soliciting the customers. Rather, the communications indicate that it is the customers who are unilaterally reaching out to JW. Moreover, there is no evidence that JW's communications with customers targeted California in any way. The communications, therefore, provide little support to FutureMotion. FutureMotion next points out that JW Batteries has regularly sold products to residents of California. About 17% of JW's total sales are to Californians, but the court notes that the percentage of sales is not particularly helpful. We have held that a website's operators can be said to have expressly aimed at a forum where the website with national viewership and scope appeals to and profits from an audience in a particular state. Although the percentage of the sales to California is 17%, there is nothing to suggest that JW has been appealing to a California audience specifically. Nothing shows that, relative to the consumer market for the products at issue, that 17% is a substantially disproportionate share of the national market. In another part of the argument, the court notes JW's average sales of about 36 products per month to California. In the case of Keaton versus Hustler magazine, a defendant who regularly sold about 10,000 to 15,000 copies of the magazine to New Hampshire residents was deliberately exploiting the New Hampshire market, and the defendant could reasonably anticipate being hailed into court in the state. That same reasoning does not have much traction in a case such as the instant suit where the number of sales is so significantly smaller. There is nothing to suggest that the sales that JW made to California were tied in any way to some targeting of that forum state by JW, or that JW otherwise appealed to a California audience even if that appeal did not produce actual sales. Indeed, based on the records submitted, the relatively small number of sales in California could well have resulted without any effort on the part of JW to court a California audience at all. Absent a large and regular volume of sales into the forum state, there must be some element of targeting the forum state that distinguishes the forum state from other states. Given the low volume of sales in the instant case and the lack of a clear disproportion of sales in California, together with a lack of any evidence of specific targeting at California, there is no specific jurisdiction over JW. And with that being said, the court grants JW's motion for dismissal for lack of personal jurisdiction and enters judgment in favor of JW Batteries. If you want to read the decision for yourself, I will put a link in the description below. There is never a paywall on the documents that I post. So the Northern District of California case is over, and we now wait to see whether FutureMotion files a new case in the appropriate district in Texas. Until then, let me know what you think of the right to repair situation caused by third parties trying to make their replacement batteries work in the Onewheel, which FutureMotion appears to have hardened against such efforts. Thanks for watching! Special thanks to my top supporters in May: John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Gutbrodj, ShadowTycho, Earthbound Star, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt Calandro, and King Aries. You can support Lawful Masses on patreon.com/ljfrench, sponsus.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.